We're gonna do a hearing. We're on the record in cause number 329544. Case of style of state of Texas versus Derek Dwayne George Jr. We have Mr. Derek Dwayne. Oh, I guess we can keep it right there. We have Mr. Derek Dwayne George Jr., who is appearing in court with his attorney, Mr. Antoine Freeman. We also have for the state, I think, Mr. Chase Inman, who is sitting first chair. And we also have Julie Maxey, who is also with the state assistant district attorney. Let me turn that camera a little bit. And first of all, the court has before it a state's motion to revoke or increase bond in this case. Now, I looked at this name. I may have a disclosure. It's Derek Dwayne George Jr. Do I know you, Mr. George?
I don't know.
Okay, now, Mr. George, so you're a junior. Your dad is Derek George?
Senior.
Senior, is he the gentleman that has a food truck, barbecue and poke bones and all that kind of stuff?
He just do turkey legs.
Okay, well, I know a gentleman by that name, Derek George, lives in the north end of Beaumont.
Oh, that's our cousins. That's the other Derek George.
Oh, okay, so you got two Derek Georges. Okay, okay. Well, I guess I don't know your dad. I thought I may have known your dad. So I do know the other guy.
Yes, sir.
And the only reason why I'm saying that is because the court is making a disclosure that I do know a Derek George, and you saying that the gentleman that does the poke bones and stuff like that, that's not your dad. That's your cousin, maybe a cousin or something.
Yes, sir.
Okay, I know him. Now, state, with that disclosure, do you, is the state of the opinion that the court should recuse itself in this particular case?
No, Your Honor.
Okay, now another disclosure to Mr. Antoine. On Thursday of last week, Ms. Maxey came into our office inquiring about the date for the this hearing.
Yes, sir.
And then and I guess in part of the conversation, she mentioned that the complaining witness was, I guess, calling her about the date. So do you think that there is something in that could be cause the court to recuse itself in this case from the defense standpoint?
I do not, Your Honor.
Okay, so you're waiving any conflicts of interest? I don't think I don't think I know the complaining witness. Who's the complaining witness? What's the name of the complaining witness? I think y'all had some.
Your Honor, her name is Mariah Thomas.
Okay, I don't think I know a Mariah Thomas. Now, state, are you waiving any conflict of interest that we may have with Mr. Derek George Jr.?
Yes, Your Honor, we waive.
Okay, so state, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
Yes, Your Honor.
Okay, so we're gonna have everyone to please take your seats and state is your motion. You may go forward.
Yes, Your Honor. On or about April 4th, 2021, the defendant in this case was arrested and charged with assault family violence. As the court's aware, bond conditions are placed on defendants that are arrested in cases such as those. The bond conditions explicitly state that the victim in the case is not to be contacted directly or indirectly by the defendant. It came to the state's knowledge that the defendant had contacted through the messenger app the victim in this case, Mariah Thomas, and the state would present to the court that that is a violation of the bond conditions on the defendant and request that the bond be revoked or any alternative increased in this case.
Okay, are you, you calling any witnesses?
Yes, Your Honor, the state would like to call Mariah Thomas.
Okay. Mariah Thomas? Ms. Thomas, would you please raise your right hand? Ms. Thomas, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, Ms. Thomas, you may sit in that chair. Mr. Bailiff, could you turn the, okay. State, you may go forward.
Thank you, Your Honor. Can you please state your name for the court?
Mariah Thomas.
Ms. Thomas, how do you know Mr. George?
Back in June, July 2020, he inboxed me on Snapchat and conversation. Conversing.
And were you two ever in a relationship?
Yes, ma'am.
And how long did that relationship last?
Up until April of this year. 2020.
And can you tell us why that relationship ended?
A lot of reasons, but this one, day, it was Easter Sunday. I was going to pick up my daughter.
Objection, relevance, we're talking about a bond here and not about the underground and assault family violence. This is only about the bond here. You don't need to know anything about the underlying assault case.
Your Honor, I'm establishing that she was a victim in the original assault case so that I can establish the violation of bond.
Okay, man, do you have to, well, I'm gonna sustain his objection. You may proceed. Okay. And this hearing is just only limited to what's set out in this motion in this hearing.
Okay, thank you, Your Honor.
Okay.
Were you, Ms. Thomas, were you the victim of an assault on April 4th, 2021?
Yes, ma'am.
And who was the perpetrator in that assault?
There.
Young, you just sustained my objection, she still did. We were
I
not
can't hear
here. You just sustained my objection, she just went back into their family assault case.
I think that the objection was sustained based on all of the facts of the, I guess, the charges that he's been charged with. Okay, okay, you may proceed.
Thank you. May I approach you?
Yes, you may.
Ms. Thomas, I'm showing you right now what's marked as State Exhibit A and State Exhibit C. Can you describe in State Exhibit A, it's 2 pages. Can you tell us what these images are?
They are text messages from their George.
And so you recognized those documents, you've seen them before?
Yes.
Are State's Exhibits A and C exact duplicates of the contents of the messages that you received on the Messenger app on your cell phone?
Yes.
And can you point out on those documents the identifying information that tell you who sent those messages to you?
Derek Jones Jr., because he uses his name. There's no other. That's how he messages. That's how he talks. That's how I know.
Can you tell us who, there's a Miss Robin mentioned in State's Exhibit C. Can you tell us who that is?
That's his stepmother.
Okay. And so based on that identifying information, who do you believe sent those messages to you?
Derek.
And the content of those messages, was it of a calm nature or a threatening nature?
A threatening.
Is there anything specific in those messages that you can tell us that leads you to feel that way?
Yes, when it says, I'll just get my girl to, beat you up, not verbatim, I didn't wanna cuss, but that, where you at, trying to get me arrested, that's threatening.
Okay. And based on those threatening messages, are you afraid for your safety?
Yes.
Okay. Do you have any other firsthand knowledge of any attempts to contact you from the defendant too?
Yes, after I talked to you Friday, his cousin Brandon called me and asked me what was going on because he doesn't have a lot of knowledge of what's going on and said that Derek wanted to do a three-way, meaning a three-way phone conversation. And he said that he wasn't gonna do it, and I said, good. because
Objection, that's hearsay.
Objection sustained.
When you received that phone call, how did you feel? Were you afraid for your safety?
Yes.
Okay. And where were you when you received the messages and the phone call?
Actually, on one of them, I was just leaving the Sheila's office, and then another one, I was driving.
So you were in Jefferson County at the time?
Yes, ma'am.
Okay. Your Honor, the state tenders the exhibits to the defense for inspection and offers them into evidence.
Is this the one exhibit?
These are 2 pages. This is just the cover page.
No objection to, exhibit A, Your Honor.
Exhibit A, no objections. Exhibit A will be admitted.
And exhibit C, Your Honor, we're gonna object on authentication. We don't think that's an authentic document. I don't think, it's been proven up to be, authentic as well.
What's, you said that's exhibit B?
That's exhibit C.
C? Let me see
We
C.
don't think that, they, authenticated that document.
What's that?
I can ask some more questions, Your Honor.
Okay.
Okay, Ms. Thomas, at the top of the exhibit C, there is a name at the top. Can you tell the court whose name that is?
Derek George Jr.
Do you recognize the picture at the top? And who's in that picture?
That's Derek.
It also mentions a Miss Robin and my daddy. And you mentioned earlier, Miss Robin is Mr. George's stepmother, is that correct?
Yes, ma'am.
And Miss Robin is married to Mr. George's father, correct?
Yes, ma'am.
It also mentions in Exhibit C a bond being revoked. Are we here today on a bond revocation for Mr. George?
Yes, ma'am.
Okay. The state would offer Exhibit C into evidence.
You know, I would also say it has not been authenticated and the statements in that document are hearsay.
Well, I mean, statements, if it's from a party opponent, it could be considered an admission. Now, in reference to it being, what was your initial objection?
I said it has been authenticated. I don't believe
Authenticated.
If she can authenticate the source of it, I don't know if she can authenticate that it actually came from Facebook. I don't know if she can even say that she's qualified to be, copying things off of Facebook and presenting to the court. I don't know where that documents come from. It could be Photoshop all I know.
Okay, objection sustained.
Ms. Thomas, where did you receive these messages? Did you take a screenshot of those messages? And is this image an exact duplicate of those messages that you received on the messenger app. Ms. Thomas, is Derek George Jr. in the courtroom today? And can you point him out and describe what he's wearing?
Right there, wearing a blue polo shirt, green, red, orange, black, and white stripes.
Let the record reflect that the witness has identified the defendant.
The record will so reflect.
Your Honor, the state would like to offer exhibit C into evidence.
We'd like to reiterate our same objections, Your Honor. I don't think it's been authenticated. I don't know what that is. I don't think they've proven anything regarding where that document comes from.
State, you have a response?
Judge, the document has identifying information from the defendant in the case. It also has information that's being given to the victim in the case that would identify the defendant as the person making those comments, or a person under the direction of the defendant making those comments. There is a picture, there is a name, as well as family information in there that would so identify the defendant as being the person that made those photos. They're authenticated because the victim has testified that they are screenshots that have not been altered. They are exact copies of the messages that she received. They would ask they be tendered into evidence.
Your Honor, that speculation, that's with the assumption that the witness is telling the truth. I still say it has not been authenticated. We don't know where that document's come from.
Okay, objection.
Wait, not admissibility.
Okay, objection overruled. Okay, document is admitted. State's exhibit number, is that B, C?
This is C, Your Honor. Your Honor, we also request that the court would take judicial notice of General Order 2019-1, which are the bond conditions for this court.
Court will take judicial notice of bond conditions.
State passes the witness, Your Honor.
Mr. Antoine Freeman?
Thank you, Your Honor. Ms. Thomas, did you post those Facebook, your example, whatever that is that they just presented to the court? Did you post that?
No, I didn't.
Okay. Where did it come from?
Facebook Messenger.
You have to speak up into the mic.
Facebook Messenger.
Okay, how long have you known my client?
Almost a year.
And you met on Facebook,
No, we met on Snapchat.
Snapchat? What is my client live?
I don't know.
You don't know where he lives?
No, I don't.
You had a relationship with him, and you don't know where he lives?
Not at this moment. When I met him, we were living with his stepmother and his dad, which he no longer resides.
Okay. Is that the same dad that you still visit? So you have a situation with this young man,
Mhm.
and you're still going to his dad's house?
Yes, because they called me.
Judge,
no longer.
objection, that's outside the scope of the direct examination of the witness in this case.
Objection sustained.
No, may I see the exhibit again?
This is A, C, I'll give you all of them.
You guys were in an intimate relationship?
Yes, sir, we were.
Okay. And you don't know where he lives, but he did live in Beaumont.
Mhm.
And you didn't make these Facebook posts and send them.
I can make a Facebook post.
You make a fake page and you send it
No,
out.
sir, I didn't.
Okay. And exhibit A, may I approach you?
Yes,
What does that say?
You want me to read it verbatim?
From
The
top to
cuss words? Okay. Bitch, you dead ass wrong for getting me
From
locked
top
up.
to bottom.
Okay. Derek George Jr., active now. Derek George Jr., Facebook, you're not friends on Facebook, lives in Raleigh, Texas.
Wait, you're not friends on Facebook?
No, we're not. We
Okay,
haven't been friends on Facebook. He unadded me. He blocked me.
he blocked you, right?
Yes, and then unblocked me.
Okay,
Okay.
where does he say he lives?
In Raleigh, Texas, but that's easy to change because mine says Dallas, Texas.
Wait a minute, so it is easy to change
From his profile,
from his profile?
yes.
But he doesn't live in Raleigh, Texas.
No, ask your client why he changed it.
Young, did you advise the witness that I'm asking the questions and not her?
Okay, just please, answer the questions that's asked.
Yes, sir.
So, a Facebook page is easily changed.
Yes.
Okay. So, this document that you supposedly got in June,
Mm-hmm.
it says he lives in Rowlett, Texas.
Mm-hmm.
I said Rowlett, you said Raleigh.
Yeah,
Well, how's it pronounced?
I don't know, but that's how it looks.
Okay. And it's not Raleigh?
I don't know.
Because
You can ask Siri.
okay. So, this is clearly not his page because it says Raleigh.
Well, I don't know because before that, his girlfriend inboxed me as well.
So you don't know if this is his page, his girlfriend could have.
I don't know who it was.
You don't know who sent this document.
It could have been his girlfriend.
You
Not the first
don't,
time she's reached out to me.
so you don't know who sent this
Judge,
document.
objection, that's been asked and answered.
I just want to clarify.
Objection sustained.
Who knows who's behind the phone? But it's his name, his profile picture, his profile.
That's all I need, y'all. Who knows who's behind this phone? No further questions.
Ms. Thomas, the content of the messages that you received, did it reference getting a bond revoked?
Yes.
And do you have any reason to believe that anyone else would have that information besides the defendant?
Just him or his girlfriend, because like I said, she was in Israel.
Can I see the? So in Exhibit A, when it mentions, "I'll just get my girl to beat your ass," would that be referencing, who do you believe that would be referencing?
Objection, Your Honor, cause for speculation.
Objection sustained.
Because she also threatened me.
Yeah, Honor.
as well.
And you have to, just respond to the question. If there's no question to respond to, you can't just respond.
And in Exhibit C, does the sender of the message reference you trying to get them arrested?
Yes.
Objection, Your Honor, cause for speculation.
Judge, that's
Literally
clearly
written
found in.
the.
Objection overruled.
And in the message where it references Miss Robin and my daddy,
Mhm.
we established that Miss Robin is married to Mr. George's father. That's correct. And so it would make perfect sense that when somebody references my daddy and Miss Robin, they would be talking about Mr. George's father.
Objection, Your Honor,
Correct?
it's called speculation and she said it makes perfect sense. I don't see it as making perfect sense. Speculation.
State.
Judge, the question is in regards to the witness's apprehension and the way they take the messages as it's received. It's not a question for speculation, it's how she receives the message.
Then objection leading, Your Honor, I still say speculation, but she's leading down the path that she wants her to go on. She's gonna ask her a question, she needs to ask it. Don't leave it.
Okay, objection to leading.
The state passed away.
Okay. Mr. Freeman, you can just probably leave that on now. Yes.
No further questions, gentlemen.
State?
Just take rest, Your Honor.
Okay. Mr. Freeman? Your rebuttal?
We have no witnesses.
Okay. All right. May this witness be excused?
Yes, Your Honor.
Yes, Your Honor.
Okay, you may be excused. Okay, the court, at this time is going to just take this matter under advisement. Um, Okay, the court is gonna, let me do this here. Now, the court is gonna take this matter under advisement. The court is going to, we do have what we call standard bond conditions that we have in the misdemeanor courts. Question is whether or not he received those bond conditions. I know that from checking our files, he has not received, at least the bond conditions from us. I don't know what he received from the jail. So of the abundance of caution, what we're going to do, I'm going to give him some standard bond conditions right now while the matter is pending for the court to decide, make a decision on whether or not the state has established a prima facie case improving that Mr. George has violated his conditions of bond. Angie, could you make a copy of this for me? Mr. Pepper, could you get us to the defendant? Now, Mr. George, what you have before you is titled "The Standard Bond Conditions in County Court at Law Number 2." Do you see that? The title?
Yes, sir.
Okay, I'll go over these bond conditions, which is say, following arrest and/or accusation in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the following additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body, and that's pursuant to the Texas Code of Criminal Procedure, Article 17.44, A2 and C2. Do you understand that condition?
Yes, sir.
Condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
And condition number 4, that only applies in the DWI case. In your case, is not a DWI case, it's a assault family violence case, okay? Now, your failure to adhere to any one of these bond conditions may result in your bond being revoked and you being arrested and put in jail on this charge, okay?
Yes, sir.
Now, I do know that, you may be seated. The outstanding bond conditions, I don't know whether or not the county jail gave you a copy of those or not, but those are outstanding bond conditions. And so now what the court has to do is look at the facts of this case to determine whether or not one, if you violated the conditions of your bond, and or pursuant to Article 17.09, the court can, if the court finds that the bond is deficient, excessive, or insufficient in the amount, or that the surety of any are not acceptable, or for any good cause, for any good or sufficient cause, such judge or magistrate may either in term or invocation order the accused to be rearrested and to require the accused to give bond in such an amount as the judge or magistrate may deem proper. Now, one of the issues we have is concerning whether or not, I got an issue with determining that you violated the bond because we don't have any evidence to show that you got a copy of the bond to suggest that you were aware that you had these bond conditions, because when we looked in the court's file, there was no bond conditions in there. Now, we do know that your bondsman give you terms and conditions of the bond that you're with him. And if you violate that, he can get off your bond, okay? So that's a different document. That's a contract between you and your attorney. You and your bondsman. Now, the other issue is whether or not these facts are sufficient to determine for the court to say that this bond is, that your bond should be increased. Okay, you got an issue as to whether or not you actually sent the this message in Facebook. But regardless of that, the court's standard bond in a family assault violence case is usually $5,000, and I think your bond here is like $1,500. Okay. Now, I don't normally when we set bonds, we try to get as much information as we can from individuals to see whether or not they're working, whether or not they got family ties in the community or family ties, whether or not their safety, the safety of the community, safety of the victim is also involved, whether or not they have previous bond forfeitures, whether or not they have ability to make bond, whether or not they have other outstanding bonds and other factors, criminal history, and other factors as I think in Article 17.15 of the Texas Code of Criminal Procedure with the rules for fixing the amount of bail. okay? And so, the court, as I said earlier, is taking this matter under advisement to, make sure that, one, the public is safe. And not only that, but the complaining witness is also safe. But there's still an issue as to whether or not, you or, I think she testified, you or your girlfriend sent the text, or I mean, the Facebook message. That's one of the issues that, we have to resolve, and it came from the witness mouth that she did say she didn't know who sent it. She couldn't say who sent it, but she has a Facebook post. I noticed one thing she didn't say. She didn't say that, this is how, I think she said y'all communicated through Facebook, but she didn't say that, it always came up through that particular page. I guess it could be a new page. With Facebook, a lot of things happen, but in any event, the court is going to take this matter under advisement, and consider the evidence that has been presented, as well as, consider all the evidence that's has presented, and also we're going to apply the facts in this case to, the law, as it relates to, the court, being able to increase bond, being able to set bond. Let's see, that's 17.40. And also, related to victims of, community safety. Let's see. And in point 17.14, it states that the magistrate may revoke the defendant's bond, only if the magistrate finds by preponderance of the evidence that the violation occurred. We do know somebody communicated with, the complaining witness. The question is, who communicated with the complaining, witness? In any event, the court still can, modify bond conditions. That's another consideration. If the court even doesn't, revoke the bond, the court can modify conditions. And I think one of the conditions, let's see, that's involving family violence. And it relates to contact. And I think the court can also require a GPS monitor, in regards to, these family violence cases. But in any event, right now, you're under the new bond conditions that I have. But the court is going to take this matter under advisement. And then, once the court, reaches a decision, both, the defense as well as the state is going to be contacted. Okay, so at this time, we'll be in recess. The court is going to take this matter under advisement.
Thank you, Your Honor.
Thank you.
You're welcome.